We are live.
All right, welcome back to the House Judiciary Committee this Wednesday morning, March 11th, and continuing with H 606. And Chris Bradley, if you could join us, thank you for being here, Chris.
See if I can fold myself into the chair here. I'm vertically not challenged. It's fun to be in front of this committee. It's only the first time, 3 days before the crossover. Thank you. For the record, my name is Chris Bradley. I'm the president and executive director of the Vermont Federation of Sportsmen's Clubs. I have the honor of representing 45 member clubs across the great state of Vermont, in addition to its 14,000 plus members. To start, the Federation strongly opposes the bill as introduced, and we have grave concerns with introducing a bill that, even though with one part removed, has 4 operational parts affecting a constitutional right in some way, and it appears that there's the impetus to move it through in 2 days. I'll begin with Section 1 that amends 13 VSA 2501 to make it a felony to steal a firearm of any value. Just as a side note, the Federation generally looks favorably on the concept of getting tough on crime. However, we question why this bill references the, if you're not aware, committee, statute has multiple definitions for what a firearm is. We question why this bill references the definition of a firearm from 13 VSA 4016, weapons in court, as opposed to 13 VSA 4017, prohibited persons, which is in fact the definition that is used in sections 2 and 3. 13 VSA 4016 defines what a firearm is regarding one being found in a court of law. As a reminder here, the Supreme Court of the United States has specifically ruled that courts are sensitive places, perhaps requiring a more expansive definition of what constitutes a firearm. Looking at Section 2, you will see a definition in 13 VSA 4017, which that's the prohibited person statute. And you'll see that that definition is far less expansive. By the 4017 definition, antique firearms, replicas of antique firearms, and black powder guns are exempted from being called firearms. And in fact, prohibited people can own black powder firearms legally, according to federal and state law. We respectfully but strongly request the reference definition of the firearm in this proposed amendment to 13 VSA 2501 be changed to point at 13 VSA 4017 as opposed to 4016. The primary point being that the firearms that are exempted by 13 VSA 4017 are not used in crime typically. Well, every firearm has some value, and some number of firearms exempted by 13 VSA 4017 may be worth well over the $900 that would currently trigger 13 VSA 2501 anyway. A significant number of firearms that are exempted are not worth the $900 value that would currently trigger 2501. And by the 13 VSA 4017 definition, they are not even considered a firearm. It is not to say that people stealing these could not be prosecuted. They could still be charged under 13 VSA 2501 grand larceny or 13 VSA 2502 petit larceny based on the actual value of the firearm. The point here is stealing a rusty wall hanger musket that may be unsafe to fire, but which would qualify as a, quote, firearm of any value, end quote, may be worth significantly less than $900 and should not automatically be considered a felony. As another point of consideration, we foresee a situation where the state could prosecute a criminal who steals a firearm under the proposed amendment 13 VSA 2501 While at the same time, the state could also possibly prosecute the victim of that theft under 13 VSA 4024, which is the negligent storage of firearms. If a person were ever charged under grand larceny for stealing a firearm, we suggest that 13 VSA 2501 be further amended to include C, with language similar to C. Charging a person under this section will disallow the victim of the theft from also being prosecuted under 13 VSA 4024. In the final analysis, a firearm is just another piece of property, and making it an automatic felony, regardless of its actual value or if it is even considered a firearm, seems out of line with stealing any other type of object that can be used as a weapon. Any questions on our stance on section 1?
Just a quick question. I assume in your written testimony, you had that language as far as what you're.
I did so.
So we can just look at that.
And it's been submitted to Nate as of this morning.
Okay, great. Yeah, I see it here. Thank you.
Very good.
Any questions on this section for? No, proceed. Thank you.
Not a problem. Section 2, amend 13 VSA 4017. Federation offers no objection to this. We will point out that there is a discrepancy between federal law and state law in that if you're a prohibited person under federal law, it's an automatic felony. Section 3, amending 13 VSA 4017A. This is a court-ordered firearms possession prohibition. In reviewing the new sections 5A and 5B, you see that these sections conform to existing federal law as specified in 18 U.S.C. 922G. Likewise, the first part of 5C also parallels 922G. We are concerned, however, over the second part of 5C, which states, I quote, "for a non-hospitalization order issued by the court pursuing to 18 VSA 7617B3. Under Vermont law, per 18 VSA 7617A, which is reporting National Instant Criminal Background Check System, 18 VSA 7617B1, B2, and B3 all require the court administrator to report the person who is subject to the order to the National Instant Criminal Background Check System, or NICS. 18 U.S.C. 922G4 bars possession by individuals who are, quote, adjudicated as having a mental defect or who has been committed to a mental institution, end quote. Historically, both the ATF and federal courts interpret committed to mean formal involuntary commitment, not non-hospitalization or outpatient therapy. Further, firearm prohibitions for prohibited people focus on people who are dangerous or confined, not people who are allowed to live in the community but who may be under treatment. This actually creates an interesting situation where Vermont law would cause a person to fail a background check when that failure is not disqualified under 18 U.S.C. 922G, i.e. non-hospitalization. The person caught in this dilemma would be required to request an expungement from the NICS system when it should never have been reported to NICS in the first place. Any questions on our stance on section 3?
Yeah, go ahead, Barbara.
So one thing that we've been hearing related to people who are competent to stand trial, and if they are either ordered to be hospitalized or have a non-hospitalization order, is often there's somewhat of a fine line. Like, it's a big range of people who qualify for the non-hospitalization order, and some of them there have been major complaints from many different sort of facets of the community, that the people really are borderline needing to be hospitalized. I think Vermont's laws, when we did de-institutionalization, sort of tilted in one direction. And so we were hearing from mental health providers that they didn't agree with the Department of Mental Health if somebody should be hospitalized or not. And so we have the psychiatrist and the person who's treating them saying that the person is either what they consider dangerous or at risk of hurting themselves or even non-compliant. Then we have the Department of Mental Health saying they disagree, and there's been no place for that to get resolved. And in the meantime, what's been brought to our attention is some of those people have committed crimes and were actually the worries that the local providers had were valid. And so one thing that came up earlier this session was like, how do we resolve that? What if there's disagreement? How does that get resolved? And so I worry, I see your point about the federal law, but I worry about the group of people, and again, I don't know what percentage it is, we don't have data on it, that are in that non-hospitalization order that really have significant mental health challenges that could make them risky candidates to have access to weapons. And I guess I just want to hear, like, if you've, how familiar you are with.
Well, as far as mental health issues, I must confess it's not my primary area of expertise. I think what you just described was the court making an error. And when they did not rule that this person was either a mental defective or required hospitalization. And I'm sure there's lots of disagreement as to when something should happen or not. But to come to your point, we don't know how many people this affects.
I don't know. I couldn't tell you.
Should the committee know that?
I think also, just to go back on your point, I'm not even sure it goes, the court is relying on the Department of Mental Health, and the issue is with that system, like getting that system fixed before, we assume everybody in the non-hospitalization category is in for a minor mental health or out for, because they have minor mental health struggles, not significant.
Well, again, I guess I have to come back to saying, if it's clear that there are issues that we should address for this individual, then I think we err on the side of caution. And that's either an involuntary commitment or we exercise ERPO. But certainly, as written right now, we're casting a net for people that are not deemed to be mental defective or requiring hospitalization. In fact, the court is actually saying, you're fine to be amongst the rest of us in the community. And if that determination is being made, then why would they lose their rights?
Angela.
I think just to put, I really support what Representative Rachelson is saying, and just to, I don't think that it's accurate to frame it as the court saying you're fine to be among the community. There are many folks who are under orders of non-hospitalization who anyone under orders of non-hospitalization has to be receiving treatment. So it's not like you're fine to be among the community, period. It's you're fine to be among the community with very specific restrictions that are related to the identified and hopefully diagnosed at that point mental health challenges. And we've heard a number of times, and we just heard from the state's attorneys and sheriff's departments who are the people in our communities who are on the front lines of trying to get a handle on the dangers posed by the Vermont context, which I think you're offering the federal context as a backdrop, but the Vermont context is different. We don't have the facilities that other states have, and we don't have the capacity that other states have. We don't have the treatment that other states have. We don't have this under control. And so I think it's a bit of an oversimplification to say we should just match the federal standards because if someone's under, on an ONH, then they're fine to be among the community. That's just not accurate.
Forgive my ignorance on these sort of things. Someone's pulled over, charged with multiple counts of DUI, and the court orders them to go into treatment for alcohol abuse. Is that a situation that would fall under this?
So just to be really clear on this, to get one of these orders under 5B or 5C, there has to be a finding that the person is in need of treatment. And that's defined specifically as being a danger to themselves or others. That's really the key in all this. And they can be given the least restrictive kind of treatment out in public, or not out in public, they're getting treated, but still that finding is what this is really keyed to. And that's the danger to themselves or others. And that would be in both 5B and 5C. And that finding would have to be made. So
If we're a danger to ourselves or others, isn't it an ERPO?
I mean, it could be an ERPO separately, or it could be this prohibition under here. Yeah, I mean, there's very similar standards for an ERPO, but somebody doesn't necessarily have. There's other. Yeah, it's just what it's. I can find the language precisely, but a danger to themselves or others due to a mental defect. So there's that. You may have an ERPO where you don't have that other connection.
If there's a finding of a mental defect, that's a separate issue. If they've been found to be requiring involuntary commitment, that's a separate issue. But we're dealing with something that's nebulous. In fact, it seems to me by the discussion we just had that we have ERPO when things are very clear that this is a person who's an issue. And by the way, we supported that when it was initially submitted. We took some heat for it, but I think we can all agree that there are people that shouldn't have guns. The only requirement there is the conditions under which that occurs, and as long as due process is realized.
Yeah, agreed with that. But yeah, Tom.
It'd be a separate determination by the court, like a condition of release on a case-by-case basis.
I would certainly think that's probably advisable because every individual is different. But what I think we're hearing here is that you have a court, there's a situation with an individual, we're not going to involuntarily commit him. He is has a mental defective, that we're going to put those two aside. But then we have this other rather nebulous situation where it doesn't rise to the state of an ERPO where we should be charging this person as or tying that to this person because there are risks to themselves or others, as has been specified. But that doesn't seem to be the case with this nebulous area we're talking about. Non-hospitalization, at this point, to Representative Rachelson's point, we don't seem to know how many people are being affected by this. Is it hundreds? Is it thousands? How many people are in this area that are being affected by this that are in essence losing their rights for some period of time and then have to go through the process of expunging a record from the federal system where the federal law didn't require that situation?
So that's really a concern, not with this language right here, but the language which we did a number of years ago, that we have to submit orders of hospitalization and non-hospitalization to the NICS system. That's where that really goes.
Was it non-hospitalization, sir?
I'm almost positive. I double checked that, but
I will as well.
Again, it's connected, and the person in need of treatment means a person who has a mental illness, and as a result of that mental illness, his or her capacity to exercise self-control, judgment, or discretion, etc., and they're a danger of harm to himself or herself or to others, and then it describes what that danger is. So it all is tied to that in these provisions. So
I appreciate the clarification, but it seems we have layers here and we haven't reached the stance of ERPO yet. And we're somewhere under that.
Angela, then Tom.
I just want to make sure that it's clear that it's not as nebulous as you're portraying it, because there are DMH, the Department of Mental Health, would have data where I think Representative Richardson was saying she doesn't have that data right now. That's different from it's not out there, it is. And ERPO, I think it's really important to keep the conversations appropriately separated because, as the chair mentioned, with an extreme risk protection order, there is not necessarily a finding of a mental defect, which is of course
Or mental illness.
terrible language,
But-
mental illness. And I think that's important because it is more of an emergency procedure and process for, an acute situation, often to help save someone's own life, hopefully prevent suicide, but also to prevent risk of harm to others. But with this provision, the sweep is different. The universe of potential of folks being potentially affected is different. And it would be known, I think, with some DMH data.
I'd be interested to see that, Representative. I understand your point. However, I do worry that for this grouping of people, that a court has not said you have to be committed, or has not said, boy, I don't think you've got all your marbles. There's something wrong here.
They have. The court
No,
has.
that's
found
finding somebody with a mental defect.
a mental
which is-
illness that has to be treated.
Um,
That's the ONH.
but you're going to let this person in the community.
Often because we
Correct.
don't have a facility or a capacity in many of our
Well,
facilities.
that's a problem elsewhere, isn't it?
Yeah,
Yeah, that's a big problem. So,
Um,
Tom,
I think we just kind of reached where I was gonna go. We say order of non-hospitalization. Hey, looking at it literally, we have no hospitals, and that's where they would most likely be if we had the facilities at the time. And if they get treated and they come off the order and they're judicially involved at the time, and they are no longer, then they would be able to own a firearm. So
unless they've been found to be incompetent to stand trial, that's 5A.
yeah, but I mean, they could be restored.
Right, yes.
I mean, it's literally because all the testimony we've had on other bills with this same type of issue is we don't have a place.
Yeah, and that's a whole other
It
issue.
won't take them because they don't have room.
Yeah, that's a whole other
Right.
rabbit hole to get down that we'll stay out of for now, but it is a really important issue, and we have been trying to address that a little bit in this committee, and we'll be continuing to. So let's move on.
Very good, not a problem.
Thank you for the discussion on that.
Very good, thank you, appreciate it. Section 4, this is amending 13 VSA 4022 to prohibit machine guns and rapid fire devices. When the Federation was initially informed that a bill would be forthcoming concerning machine guns, we initially understood that the primary concern was to address Glock switches, or devices which, when installed into a Glock, would allow the firearm to become fully automatic as opposed to being semi-automatic. Per existing federal law, it is illegal to make a machine gun or to possess a non-registered machine gun, a crime that is punishable by not more than 10 years and or a fine of up to $250,000. Federal charges regarding machine guns can also be stacked, meaning a person can be charged under, say, 26 USC 5861D, which is possession of an unregistered machine gun, as well as being prosecuted under 18 USC 922O, which is the illegal possession of a machine gun. If you're not aware, currently there are 37 states, including Vermont, which allow for the legal ownership of machine guns. Obtaining one is not simple, not only because the number of machine guns that can be legally owned is a finite number since 1986, the Hughes Amendment, and that is a number somewhere around 180,000 total, legally owned, and are therefore ridiculously expensive to purchase. But also because the process to own one is far, far more expansive than just going and doing a normal background check. I'm happy to explain what that process is if you'd like me to go into greater detail. One of the types of devices that can be legally registered in Vermont and still purchased today legally with the ATF is an autoseer. While we can determine from the ATF the number of legally registered machine guns in Vermont, we cannot tell what they are because there is a tax involved, a $200 transfer tax, which makes that information private. It is entirely likely that there are legally owned autoseers in Vermont today. Beyond that, autoseers can be legally owned by something called a special occupational taxpayer, or an SOT, which is a Class 7 FFL, Federal Firearms License. There are different classes. And as of this year, as of actually 2 nights ago, there are 12 such FFLs in Vermont. As a simple matter of history, the Federation is not aware that there have ever been any instances of a legally owned machine gun ever being used in crime here in Vermont. And as far as the use of legally owned machine guns being used in crime across the United States, I could only find 2 across the entire US in the last 4 years. So crimes with legally owned machine guns are more than just rare. Beyond the problems in the rewritten section regarding machine guns, we have serious problems with the definition of, quote, rapid fire device, as found in A3. For many years, triggers on firearms have allowed the pressure required to trigger that makes the firearm fire to be adjusted, allowing the trigger to be made lighter or heavier. Making a trigger heavier would require the person shooting the firearm to have to exert more pressure on the trigger to make the firearm fire. Conversely, making a trigger lighter would require less pressure. The bottom line is that a trigger is set to 7 pounds of pull, or the tension you have to put on the trigger to actually have the sear release and the hammer fall to make the gun work, is not going to operate as fast as a trigger with a 2.5 pound trigger pull. Legal triggers can also have something called a positive reset. This feature puts a slight amount of forward force on the trigger once it has been used to fire the firearm, essentially pushing the trigger forward slightly, allowing the shooter to use less energy to move their finger forward, thereby allowing the trigger to reset, that would then allow the trigger to be fired or pulled again. By the definition of a rapid fire device, an adjustable trigger would qualify as such a device that would increase the rate of fire, so the legal installation of a legal adjustable trigger would become illegal. In rifles like the AR-15, where the rifle is fired, gas that results from the propellant being ignited forces the bolt back against a recoil buffer that compresses a spring behind the bolt, which, after being compressed, then forces the bolt forward. Depending on how hot the ammunition is being used, simply changing the recoil buffer can increase the rate of fire of a firearm. To Representative Burditt's point, in its simplest form, the index finger of a shooter is a rapid fire device, because the more one exercises that trigger finger, the faster one can actuate a trigger. One of the things I'm not sure we've discussed so far is what is the standard rate of fire of a semi-automatic rifle or pistol? Essentially, it's as fast as you can do this. With practice, shooters can achieve rates of fire on the order of 8 shots in 1 second. That's with a revolver, not a semi-automatic, a revolver. And in fact, that's 8 shots in 1 second. And if you want to ever look at a video, Gary Michulik He is able with a 6-shot revolver to fire 6 shots, reload that revolver with 6 new shots, and put another 6 shots for a total of 12 shots onto a single target in 2.99 seconds. That's with a revolver. That's not a semi-automatic. Just as a side, I've included here a common rubber band can be used as a rapid fire device. And essentially the way it's used is it forces the trigger forward. You know, trigger, when you pull the trigger, trigger breaks the sear, hammer falls. If you put a rubber band around that trigger like this, so that when you fire the trigger, the rubber band wants to pull your finger forward. I've got a video if you'd like to see it being used. A rubber band is a rapid fire device.
I see it is linked in your testimony. So.
Even without a rubber band, almost all semi-automatic rifles can be bump fired, a technique that does not use a bump stock, to achieve faster shooting without any device being used. The Federation does believe Vermont law enforcement should not be put in a position to decide what is or is not a rapid fire device, when it is almost impossible to determine without disassembling if a rapid fire device is installed, or through the achieving of rapid fire with no device at all. With the framework provided by the Bruin decision, combined with the Heller decision, has led courts to reason that items necessary for a firearm to function, such as triggers and stocks on a rifle, items which are necessary for the firearm to function, likely fall under the definition of arms and are thus protected by the Second Amendment, so long as those components do not allow for fully automatic fire. We believe that Vermont should parallel federal law by simply stating that making a machine gun is illegal and leave out attempts to define what is or is not a rapid fire device, things that are better left to the ATF and the federal government. As an aside, bump stocks, which this section is amending, are not illegal by federal law. Forced reset triggers are not illegal by federal law. Binary triggers are not illegal by federal law. Yet all of these are components. If we try to ban a stock, you're banning the firearm. And all we've got here is a bump stock that allows the stock to slide. It's still a stock. Chair Lalonde, I had written a couple of paragraphs concerning Section 5. Perhaps I don't need to belabor the committee with it, but I'd love to.
So yeah, I mean, I know it's a little bit longer in your written testimony, but if you can give me the basic points.
I'll read them quickly.
All right. No,
I mean, it's literally just a page here.
okay. Yeah. No.
Well, closer to 2, full disclosure. This was a new subchapter 5, 13 VSA 4091, 2 and 3, liability for public nuisance in firearms lawsuits. The Protection of Lawful Firearms Commerce in Firearms Act, better known as PLACA, was passed by Congress in 2005. What PLACA was designed to do was to prohibit lawsuits against gun retailers and manufacturers for things that could happen when their products were used for an illegal activity by third parties. PLACA does not shield a firearm industry member from wrongdoing, such as knowingly violating federal law, failing to maintain records, selling to a prohibited person, or making defective products. Instead, it targets lawsuits that attempt to blame lawful businesses for unlawful misuse by others. 15 U.S.C. 7903 5A3, however, does allow civil lawsuits against gun manufacturers or sellers if they knowingly violate a state or federal statute specifically applicable to the sale or marketing of firearms, and that violation approximately, not approximately, caused the plaintiff's injuries. This is referred to as a predicate exception. Because of that predicate exception, in recent years, several states have attempted to bypass PLACA by drafting statutes that define certain firearm industry practices as, quote, public nuisances. And such laws attempt to reframe traditional liability standards to open the door for unlimited litigation against manufacturers and sellers. To be crystal clear, PLACA states in 15 USC 7902A, a single sentence, a qualified civil liability action cannot be brought in any federal or state court. Yet that is exactly what Section 5 attempted to do. To support Section 5, proponents have pointed to a court case called NSSF v. James, a case that was decided on July 10th, 2025 in the United States Court of Appeals for the Second Circuit, which upheld a ruling by the U.S. District Court for the Northern District of New York with that opinion stating that PLACA did not apply when a state passed a law that specifically allowed nuisance lawsuits to occur. At issue is the New York General Business Law, Section 898, which imposed civil liability for gun industry members who knowingly or recklessly endanger the safety or health of the public through the sale or marketing of firearms. When Section 898 was enacted, the governor of New York stated that New York wanted to, quote, reinstate the public nuisance liability for gun manufacturers, end quote, something that PLACA specifically forbids from imposing to, quote, right the wrong, end quote, New York believed Congress committed in passing PLACA. Just so you all know, a petition to review the Second Circuit's decision in NSSF v. James was filed with the Supreme Court of the United States on February 20, 2026. That petition asks the question, quote, whether PLACA's predicate exemption allows parties to bring the same common law suits against firearms industry members that Congress enacted PLACA to prohibit, so long as states codify these general common law principles in a statute that applies to commerce in arms. That petition further said, simply put, nothing in PLACA compels the nonsensical conclusion that the predicate exemption empowers states to sneak in through the back door the very claims that Congress tossed out the front. It further states, quote, the notion that Congress simultaneously green-lighted suits advancing the exact same unfounded theories, so long as they are initiated under a statute that codifies the same general common law principles that it found did not support them, defies common sense. As opposed to the Second Circuit decision of appeals decision on PLACA, there is a case out of the Pennsylvania Supreme Court that also dealt with PLACA, a case called Gustafson v. Springfield, which was decided March 31st, 2025. Wrapping up. Per the Pennsylvania Supreme Court, quote, instantly, we find that PLACA contains an express preemption clause, which explicitly preempts state law relative to qualified civil liability actions. The PA Supreme Court also found that PLACA was completely constitutional and that it prevents exactly what Section 5 intended to do. A central question with Section 5 is whether Vermont could pass legislation that intentionally attempts to work around federal law. The clear answer to that question is a firm and resolute no, due to Article 6, Clause 2 of the U.S. Constitution, better known as the Supremacy Clause. The Supremacy Clause specifically states, quote, this Constitution and the laws of the United States which will be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. In a separate 5-page document that I've submitted with this testimony, the Federation provided a preliminary analysis of the negative effects of Section 5 on the Vermont firearms manufacturers, FFLs, stores that sell select firearm accessories, and even Vermont citizens should they ever choose to sell a firearm. The wording of PLACA is clear. unambiguous, such that section 5 is quite simply unconstitutional. Any questions?
We're not gonna have questions on it because we're not really doing anything with it. I just
Well,
wanted
not
them
on
to be able
section
to.
five.
Oh, okay, all right, yeah, go ahead,
I wanna
yeah,
go back
yeah,
to the
yeah.
question, not on section five.
Okay, yeah, yeah, go ahead, Zach.
Well,
Because there's no section.
well, yeah.
Section 5, that is.
No, I wanted to know,
I
right, that's fine that
appreciate, I
you put it on the
appreciate the
record.
color though, on section five,
Can you put it
very
on the
much.
record?
Thank you, Chair. Chris, thanks for coming in and for your testimony today. I just want to state for the record that, I mean, this has probably been one of the single bills that we've received the most outreach on. And at last count, I had 744 emails opposed to the bill, and I just received my second one in support. So I just want to state that clearly for the record. I guess my first question is, if memory serves me right, you were part of a study group last summer that was on safe storage of firearms. I know
Relinquishment of
relinquishment of storage. I know that you've been, you've testified before the committee a number of times, and have been a great partner to.
I've missed you guys.
Well, we've missed you as well, and expanding our knowledge on very important issues. So knowing all of that, and that you have been really a frequent flyer in this committee for many, many years, were you consulted at all on this bill during the drafting phase?
No.
No. Okay. The next thing I just want to state clearly for the record is in terms of modifications to the legislation as currently, in front of the committee as proposed, what modifications would you and the Federation suggest to make the bill? I mean, I have concerns about the constitutionality with the Second Amendment with this bill, but I'm curious, as if we go back to the mental defect section in section 2, I'm curious if there's any modifications there that you might add.
The only thing.
Sorry, not section 2, section 3.
Yeah, so we have concerns over the non-hospitalization.
Okay.
Because to a certain extent, Representative Harden, we already live under federal law.
Right.
And whether I like it or not, that's the law of the land. So when we see situations where the state, and I must say, listening to the sheriffs, they weren't concerned about Section 4 at all with machine guns. That struck me as odd, but I guess we do. Number one, I think you hit a very important point. We would like to have some input before a bill gets thrown over the wall. And Chair Lalonde and I have talked about that. And not that we're trying to steer anything, but I think we can steer away from cliffs that are tripwires here. The non-health hospitalization was of concern to us. We're always very concerned when a fundamental unalien right can be taken away. I guess I can leave it.
Yeah, no, I agree with that. And I think what might start at the Second Amendment could easily go to the First Amendment. Right. And I think that is the broader concern of a lot of people that have concerns with this legislation as written. The other question I want to get back to is on page 8, line 1, talking about rapid fire devices and the rate of rapid fire. And my question there, I thought your testimony was extremely compelling in terms of the concerns that you pointed out there. But I'm wondering if there's other states that have already established that rapid rate of fire, and if you're aware of what those qualifications are.
Actually, I have not researched it. I mean, I'm a competitive shooter, pistol, rifle, predominantly pistol. You really need to. I would suggest, and I can send a video if you'd like to see Mr. McCulloch with a pistol.
I would.
And one of the things we're banding around here is we really don't, what is a rapid fire device? And when we're applying one, what is the standard? How fast does this firearm fire just without any rapid fire device? Or if I just sit and watch TV and just keep doing this, I will get more proficient at it. I can use a lighter trigger. We're kind of, if it's not a machine gun, then it's a semi-automatic. And I know a lot of these terms start to get lost, or what's a revolver? I mean, what's an auto sear? There's a lot of detail that you can't expect everybody to know, but we live it, or I do.
Right. And I think that is also incumbent upon the members of this committee to take the time to make sure that we get this right. And I think short of modifying language to ban rubber bands in the state of Vermont, it seems that it would be very ineffective to have any kind of consideration of what a rapid fire device would be.
I couldn't agree more. I mean, if it's not a fully automatic, which, hey, throw the book at them. They cannot make that by federal law. And in fact, let's get serious. We're going to make, it shouldn't be a misdemeanor if we're going to get serious about it. But anything other than a fully automatic, which should be controlled and is controlled, it's a semi-automatic. And when we can have rates of fire that just sound scary because somebody practices, that touches on self-defense and the ability to defend oneself.
Thank you.
So just a couple things. Yeah, we do need to look at this way. But just as far as, I wouldn't say that we've consulted, but I've made sure that Chris and his organization knew what was coming last fall. And when he got the language and started looking at it, was actually Chris initially raised a lot of the complications and concerns with the last section regarding industry. And largely because of understanding the complications from you, Chris, that I pulled it out of this bill because it needed more time. So I appreciate the cooperation with the
I place myself at you and the committee's disposal. It's a complex issue. It's difficult to understand all the nuance to it. But we're dealing with a fundamental constitutional right. It predates the Constitution.
I keep Chris and his organization informed of what's coming up.
I did not mean to sandbag you, and I think we will be working much closer moving forward. In fact, 571, the relinquishment group, we've had lengthy discussions on, and that's, I think it's agreed that it needs further work, which is why we're not seeing it.
Yeah.
Just a quick question. On section 4, I think you testified that there were virtually no crimes committed in Vermont with a machine gun.
Legally owned machine gun, that's correct.
Illegally owned machine gun. Okay.
I'm not even aware of illegal machine guns. There may very well be.
I guess my question, I'm not trying to poke it. I just want to try to understand the data. And so like an example of what I'm thinking about is like drug bust where there's I guess this gets back to a bigger question for me. Like, is a Glock with a switch, is that a machine gun?
Yes.
Okay. So
a Glock switch is an auto sear.
okay. So and then in that case, in Vermont, if you got a drug bust where there's a Glock with a switch there, and there's a charge there involving that, is that a crime involving a machine gun in Vermont?
It's certainly a crime, not until you have it this passed.
Yeah.
Because there is no reference other, you can't hunt with a machine gun. There is that stipulation. But no, we rely on federal law and the feds to prosecute machine gun crime.
So there's really no data right now about how much crime is being committed in the state where a machine gun is involved that's not legally owned. To answer that question, you'd have to look at the Odyssey system. Yeah.
And I've been fortunate enough to do freedom of information, because this goes back to something that Representative Harvey was looking for. Hey, how many times are crimes being charged? And I specifically looked at all firearms crimes. Interestingly enough, Odyssey will tell you all active cases, and then they'll tell you all closed cases, but there's not a clear connection between the two because cases can span years.
Yeah.
So I can tell you I was very disheartened when I looked at my initial findings, which I'm happy to share from 2 years ago, because you're crunching on a lot of numbers, matching what a conviction is, which has a different identifying number or a charge than a different number that's used in conviction. And plus you have all the nuances of, I would charge you with X, but it was reduced or thrown out completely when it finally made it, if it made it to court. So in direct answer to your question, I'm not aware of any statistics. In the example you provided, first of all, there's drug bust going on. There's already some prohibited activity.
Yeah.
If a Glock was found there right now, that would be turned over to the feds until you do something. Hey, illegal possession or making, follow federal law. I mean, it's already there. But, and you're catching a guy with a drug, chances are that's going to be pled away or dropped. honestly, from what I see on conviction data. Because not only do we have a problem with hospitals, we have a problem with prisons.
Okay, thank you.
Not a problem.
All right, so we're going to go to Joe Laporto. Yes. Thank you very much, Chris.
My great pleasure. Thank you very much for your time.
As well.
Can I interject with a question for the committee?
Yeah, for the committee, yes.
Just based on Representative Harvey's comment about only receiving, I think you said 1 or 2 in favor, emails in favor.
I just received my second Rep. Arsenal.
So I'm just curious that I've received over 125 in favor and they all went to my other inbox.
Trust me, I've been looking at
So I know
spam and
if-
filter. I've received 2.
Yeah.
744 in support and 2.
I haven't been counting emails, but I've gotten a whole bunch of both.
I filtered everything into one, so I would have it all in one place. So
I
could
just
start
wondered
interacting
if
with
they were
constituents.
All right, so we're going to go ahead with Joe. Go ahead. Thank you for being here. All right.
Thank you, Chair. Well,
DC, I understand. or-
we're headquartered in Fairfax, Virginia, right outside of DC. I'm Joseph Laporta, representing National Rifle Association. I'm the state director for Northern New England, so I work both here in Vermont, including New Hampshire, Maine, and Massachusetts as well, and on a team that covers state and local issues nationally. So I hope I can perhaps offer some perspective on some of these issues, given that we address this type of legislation in all 50 states. I will keep my prepared comments relatively short. I think Chris has covered a good deal of the sort of formal comments on the core areas of these sections of the bill. We largely concur, and on behalf of our members, we would oppose the current draft of the legislation.
The amendment, just to be clear, the amendment.
The amendment as it published yesterday.
Okay. All right.
So we still have, we thank the committee and the chair for addressing the issues with regards to Section 5, but just as Chris has expressed, we have concerns regarding some of the other provisions in the proposed bill here. And again, I'll keep our comments sort of somewhat limited. I think Chris covered it. We share the same concern with respect to Section 3 as it relates to non-hospitalization orders. And I fully understand that there's a sort of calibration issue with regards to Vermont health law. But I would point out to the committee that under the sort of civil commitment procedures in Vermont health law, the standard of proof that an applicant has to carry in order to obtain an actual commitment, an involuntary commitment, is quite low. It's probable cause showing. So the court is given a fair degree of latitude to make the determination as to whether or not someone is at risk and should therefore be committed. Now, we understand that Vermont law provides flexibility, right? So a court facing a civil commitment case doesn't necessarily have to choose between, a commitment order versus just letting that person go. We've created some additional flexibility here, but mental health issues are on a broad spectrum. So the fact that a court uses its discretion to say that there should be some outpatient treatment here, again, which is inconsistent with federal law in terms of making that a federal prohibition, it's unfair to say that everyone that falls into that category naturally is a danger to themselves. There's a low threshold to making that commitment application, that involuntary commitment application. And the court is essentially saying that despite that low hurdle, there's no finding here that justifies that. So we're coming up with an alternative plan. The state provides resources to both individuals and law enforcement agencies, health providers through the ERPO statute. So to the extent that a non-commitment order is granted, there's still the flexibility, if there's concern with the court, they could pursue an extreme risk protection order, but they're choosing not to. And so that the requirements, and this has to some degree been tested in the U.S. Supreme Court, not precisely on the issues surrounding mental health, but last year there was a fairly significant benchmark type case, U.S. v. Rahimi, where the court held that where there is due process and someone has been adjudicated as a threat to themselves or others, they can be temporarily disarmed in a manner that's consistent with the Second Amendment. So we require adjudication and due process here. And again, the calibration issues with regards to Vermont law notwithstanding, a non-commitment order is simply not that. In fact, in light of the fact that under Vermont law, those civil commitments are being reported to NICS, in practice, a person who receives a non-commitment order should be able to go to the federal government and say, look, I was not committed. I should not be a prohibited person under federal law. And I would also point out that the state attorney general correctly points out that the mechanism for which someone receives relief from this provision has kind of been fallen off the wayside. And that also raises concerns here. There's a procedure for obtaining an expungement for a civil commitment. Now we're going to require folks to go out and pay substantial amount of money in legal fees to get a expungement for a non-commitment order. That both burdens the respondents in these cases, but also burdens our court systems here, who now have to deal with additional expungement requests that relate to non-commitment orders, non-hospitalization orders. So it's complex. I understand the unique resource constraints here in Vermont, and the legislature has, in its wisdom, created a lot of flexibility for courts to try to address these issues. The problem is we're casting too large a net by including all non-hospitalization orders and saying, well, the folks that are on one end of the spectrum are just going to be, victims of circumstance here. And, we're going to punish them as collateral damage because we're concerned about the folks on the other side of the spectrum. There is mechanisms in state law to deal with those issues. And you shouldn't bring things out of synchronization with federal law on this issue. So
I'm trying to square what I heard from the Department of State's attorneys and sheriffs that we're actually carving out not as broad as the federal law, which is just
correct.
Having a mental defect. And I'm hearing from you, and I think from Chris, that we're actually broader. And I'm trying to square that.
Well, I think the bulk of Section 3 of this bill is largely just redundant to federal law. And because it deals with circumstances where it sort of automatically is relieved for the most part, that makes it less restrictive than federal law. And we're not going to weigh in on the issue of whether or not this is truly appropriate. I think largely this is redundant, right? 922G in large part deals with the vast majority of Section 3 of this bill. So from a policy perspective, we're just making something illegaler that's already illegal. Like it's duplicative at best. To the extent that local prosecutors want flexibility to deal with those issues, and that's why you need to create sort of a companion bill to federal law and state law. We can certainly understand that as a policy objective that these folks, there is no avenue to address this in a federal court. State prosecutors need a way to deal with this. So we understand the issue. The real problem is just the lack of synchronization with the federal requirements. And I do think there's a way to address that.
I think
we'd be happy to work with the committee on ideas to resolve this.
So I think as introduced, it was more along the lines of issues with some individuals that weighed in that we wanted folks to be able to get their firearms back, the right to possess firearms. Yeah, fairly straightforward with the language that we have in here. So that's kind of the policy decision that we have before us. But Ken.
Just want to back up a little bit. The drug busts that were already brought up, and then or the federal and stuff like that. If you have a drug bust, I mean, obviously it's more than likely federal. It's going to be federal involved, and I mean, it's pretty well documented that drugs are being run from other states into Vermont, and they're bringing the necessary weapons with them to go and cover themselves and do more harm, and putting more Vermonters in jeopardy and stuff like this. So the people that are anti-gun, they're left with nothing innocent people are left with nothing to defend themselves.
That is the concern.
So the good old saying that if you outlaw guns, only outlaws will have guns. I mean, this is a perfect example of that. The other thing I want to address is a hospital, the lack of mental health or whatever whatever the proper wordage is. I've been in this as a state rep for over 8 years now. And even before I came into this building, we were dealing with the mental health aspect and prosecution or lack of prosecution with 3 instances that we had in Burlington weren't being prosecuted because of they pleaded insanity. And then I think all 3 of them eventually were charged that they were sane. I don't believe we've done a whole hell of a lot with help in that situation. So again, that puts the law-abiding citizens that do have guns, we're paying that price there for our lack of ability to address that situation
Yes.
of hospitalization and getting people the proper help that they need to hopefully make a difference in their life. The other thing I just can't get over, again, in my over 8 years in this house, how we go and we plead down, and I don't have state's attorneys in here, but how we plead down and a slap of the wrist all the time. And the same people get out over and over and over. There's a big reason, and everybody wants to blame it on COVID. I don't fall for that, right? It's like we just have docket after docket after docket because we won't hold accountability. And again, we're taking rights away from people that deserve to have the freedom. I want to know. So,
One second, I agree with your sentiment here.
so any idea how to fix that?
Well, I think that could dovetail into our sort of comments and concerns regarding section 4 of the bill as well, right? I mean, I think we again would share much of Chris's concerns with regards to definitional issues here, but from a policy perspective, you're now taking
I
a
love
very,
that word policy.
yeah, or you're taking
One of my favorites.
you're taking a very serious federal charge and reducing it to a misdemeanor under state law. I mean, there's an argument that you are potentially at risk of causing proliferation of illegal machine guns because and this is one of the discrete problems of this bill. And we have worked on this on multiple states. I'm happy to answer questions with regards to how other states are addressing the issue. But as was queried earlier, like what is an auto scare? That is a legitimate question. And it's one that a prosecutor is going to have to grapple with under this bill. So the thing that you're most concerned with, the proliferation of block switches and the utilization of those things in, let's say, gang violence, and there are certainly major urban centers in this country that are dealing with a scourge of violence around that. And they need the flexibility in state law in order to prosecute those cases where the DOJ or ATF is unwilling to take them. So yes, we can understand the policy goal there, but now you're creating a separate thing without a clear definition that a prosecutor is now going to have to deal with a factual matter as to whether or not the thing in question meets the statutory definition. And that is what makes these federal cases very complex. The ATF has a fairly large branch within the ATF whose mission is to do technical analysis and reach technical conclusions as to what does or doesn't fall under federal definitions. In federal cases, they actually, when they prepare testimony in those federal prosecutions, they're actually engaging in rulemaking when they make a determination as to a specific thing in a case. So when an ATF agent says, we've tested this particular device, it meets the definition of a federal machine gun, it's unregistered, that is satisfying that legal definition as opposed to leaving the burden with the prosecutor to prove what is or isn't an auto sphere. So this bill is taking this issue and making it, on the one hand, making it difficult to prosecute the actual concern at hand. At the other hand, you have rapid fire devices in the same context here, which is problematic in the whole other direction and probably of greater concern to gun owners across Vermont, in the sense that the way this is currently written, virtually anything could fall within that definition. That leads to something that's very ambiguous, that leaves the door open for selective enforcement, or arbitrary enforcement, or quite frankly, no enforcement at all. I mean, I think there was questions earlier about what other states are doing here, and we've certainly seen some examples of what I would describe as experimental legislation on this issue. And there's other language alternatives out there, but what we can't really find is evidence of enforcement on this issue. So again, from a policy perspective, if we're writing words on paper that no one's going to practically enforce because it's either too difficult, or in this case, in part because the penalties associated with it are too small. If I've got a misdemeanor charge and I'm a prosecutor and I've got to go through this big technical hurdle with expert witnesses in order to prove what is or isn't an auto sear, they're more likely, to your point, Representative, they're more likely to just drop that charge altogether. And that leads to, that doesn't solve problems here. So,
So question, Angela.
Yeah, so 2 questions about that section then, based on what you've just shared. Would the NRA recommend that we change it to a felony?
my suggestion, and one we've had both internally with the Federation and Chris, and we would be happy to work with the committee here. There have been states that have simplified this whole problem, right? They pass a law that defines what a machine gun is in a manner that's consistent with the federal definition. And then they say anything that's subject to registration under the NFA that is possessed without proper registration is covered here, and anything that's not subject to registration is not covered here. So what the state is doing is basically saying we're just going to rely on what those federal determinations are. If it meets the federal definition, then it is a crime under state law, and shifts the burden on figuring out what is or isn't a thing under this statute to the federal government, which again has the resources to do that. And that would smooth that out. Now, as to the penalty associated with it, that's a policy question that I can't take a position on behalf of our membership, but most states do, they're doing this properly, regulated as they are regulated under federal law. Federal law does not create separate categories of things. Under federal law, a Glock switch is a machine gun. If that were possessed illegally, in other words, not properly acquired or registered under the National Firearms Act, whether it's attached to a thing or not, that is by itself a machine gun. And as Chris mentioned, it's stacking charges. So if I have 10 of them in my pocket, I could be facing 100 years in prison.
And then my second question was, do you have a better definition then for if you're concerned with prosecutors' ability to determine, the technical aspects of a device? Does the NRA have a stronger definition?
I think the answer is just the problems with both of these sections is the asymmetry in between state law and federal. Federal government is providing a uniform framework. So someone who has taken the steps to properly acquire one of these things and registered it under the NFA is relying on those federal definitions. They shouldn't be treated differently under state law, just simply track and copy and paste the federal law into state law. And again, take the determination process out of the equation by just deferring to the ATF as to what is or isn't a thing. And for context, an auto sear is a type of machine gun. It's a very technical thing, right? If I were to take a piece of coat hanger and cut that wire to the right length and I twist and bend it in the proper dimensions, I have created a machine gun under federal law and can be sent to jail for 10 years for doing that, for possessing the coat hanger. Again, it doesn't require attachment to a firearm under federal law. It is a machine gun. Now, the merits of that kind of a policy, we're not either endorsing or supporting that. We're just saying that the federal government has a regulatory system here that is quite complex, that requires a lot of technical expertise that perhaps Vermont may or may not have, and would therefore limit the prosecution of these cases where it matters, right? I mean, I don't think on behalf of the NRA, we support law-abiding, responsible citizens. We're not here to protect the rights of drug traffickers and gang members in inner cities, right? That is illegal conduct, and to the extent that people are breaking the law, they should be prosecuted.
So are you good? I'm sorry. Angela. Go ahead.
So to possess a Glock switch is a federal offense.
Correct.
It's not illegal to sell it, though.
It is, yeah. It's illegal to transfer or possess an illegal machine gun unless you're.
I could find them for $150 on.
Well, that is a problem, right? I mean, there's Glock switches are selling in inner cities for $20 a pop. That is a serious concern. And we understand the issue. right, the need for sometimes for state companion law to provide flexibility for prosecutors to deal with the problem at hand. Although I do think, as Chris mentioned, I think it's interesting that the Attorney General's office just doesn't see the problem here. So they may not be seeing the issue in, say, Burlington or Montpelier, but it certainly is an issue in Chicago. And these things are fairly easy to acquire. You know, they're largely being shipped in from overseas. And that is a bigger issue that is outside the sort of regulatory framework of firearms in the United States.
And they can be 3D printed also, so.
There's other issues there. But
Yeah, what went through my mind, when you said that, and I knew you could, you know, you can go online and buy them or whatever. I didn't know if maybe, was FFL 7?
SOT, yeah, FFL 7 is allowed to make and manufacture things.
Right. So I didn't know if maybe they were allowed to be sold for.
No, I mean, so the Hughes Amendment was passed in 1986, and that sort of trapped in amber all machine guns that were in existence as of 1986. So nothing manufactured post 1986 can be transferred to anyone lawfully who isn't a SOT Class 7 FFL. And they can't really transfer it to other people. Like if you are one, there are exceptions in certain states where FFLs will manufacture those types of items for law enforcement or military use, but they're not transferable to the average citizen. So I hope that clarifies that.
I'm done for the moment, sir.
All right, I appreciate that testimony. Thank you.
I thank Kitty for the time. Thank you.
So we will go to Billy Clark, and just as a time check for you, and Billy, the folks that we're not gonna make it to today, we're gonna take it up again tomorrow afternoon at 1 o'clock. But Billy, you can get started, and if you need a little bit more time to go through your testimony, we'll try to have you back tomorrow afternoon. So over to you, and unmute yourself and proceed.
Excellent. Thank you so much. And thank you all to the committee for the invitation to speak with you today. My name is Billy Clark, and I'm a senior litigation attorney and Second Amendment issues manager at Giffords Law Center. I'm also a licensed Vermont attorney who practiced in civil litigation in Vermont for several years before I joined Giffords. So I do want to speak quickly today in support of H606 as it was introduced, specifically Section 5's industry accountability section. But then I want to move on to testify in support of Section 4 to talk about this machine gun, rapid fire devices, and auto sears that we've been discussing a bit over the course of this morning. So Giffords strongly supports industry accountability laws that bring the same oversight to the gun industry that nearly every other business in America faces. Since 2005, the gun industry has profited off special treatment that it receives from the federal government. Unlike nearly any other business, the gun industry has exceptional immunity from civil lawsuits, an immunity codified in the Federal Protection of Lawful Commerce and Arms Act, PLACA, which has been referred to this morning. PLACA protects irresponsible gun industry members from the foreseeable consequences of their action and closes the courtroom door to those who bear the most acute harms of the gun violence epidemic in this country. PLACA's immunity, however, is not absolute. PLACA explicitly allows for lawsuits against gun industry members who knowingly violate a state or federal law regulating the marketing or sale of firearms. This is the predicate exception that's been mentioned. So because of this, states remain able to enact and enforce laws that establish standards of responsible conduct for the gun industry. PLACA's predicate exception is designed to balance the supremacy clause, again, which was referenced today, with state sovereignty. One of PLACA's core purposes, which is spelled out in the statute, is to preserve and protect the separation of powers doctrine, the important principles of federalism, state sovereignty, and comity between sister states. So PLACA did not attest to prevent states from ever regulating firearms. In fact, PLACA's predicate exception allows states to exercise their traditional police powers to pass laws that can fall under PLACA's predicate exception. So there's currently 10 states that have enacted legislation that require the gun industry to implement basic responsible business practices to prevent harms like trafficking, illegal sales, and gun theft. If a member of the gun industry violates the law and someone is harmed as a result, then victims and/or government officials can sue the industry member. These laws ensure that the gun industry faces financial incentives to behave responsibly and that victims and survivors of gun violence have access to justice for the harms they have suffered. So again, we strongly support Section 5 of the bill as it was introduced and ask this committee to reconsider the amendment to remove this from the bill. But I do want to go on to Section 4. And I do want to just sort of, I want to kind of tailor my testimony to try to address some of the questions that have been raised today. So I know there was one question about the federal government's willingness to prosecute machine gun cases, rapid fire device, and auto seizure possession cases. And I do think it's important to talk about the world we're in right now, which is one where is major instability and capacity challenges at U.S. attorneys' offices around the country, and in particular in Vermont. I think this committee knows, it's public knowledge, that Vermont has been without a permanent U.S. attorney since President Trump's inauguration. It has gone through a series of different acting officials and line deputies who are doing their best to keep things going, but this is not how a U.S. attorney's office is typically staffed. And that does bring challenges to bringing criminal cases, including, federal machine gun charges. I would also mention that the gun industry is currently bringing constitutional challenges to federal machine gun laws. So to say that this is solely, a matter of federal regulation and federal regulation is fine, well, there's logistical challenges, given staffing and capacity concerns to bring these cases. And then there's also a concerted attack on the actual laws that would be enforced. Mostly this is focusing on Commerce Clause grounds, not to get too into the weeds of constitutional law, but it's less focused on Second Amendment grounds where there's a long historical tradition of regulating unusually dangerous weapons, and so machine guns have not been found to be protected under the Second Amendment, or that it would violate the Second Amendment to ban machine guns. But what has been done is there's been a targeted effort to say that the federal law regulating machine guns exceeds Congress's powers. Now, we'll see whether those are successful, but to say that we're living in a world with settled federal law and no need for the states to get involved, it's not inconceivable that this federal law could be invalidated. And so there would be this gap that states could come in to fill. Another question that I heard asked was about whether there have been any cases involving machine guns in Vermont. I know there was some question about whether it's legal possession, illegal possession. I did just want to flag 2 illegal possession cases, at least that I'm aware of, that have been prosecuted. It's harder to pull state records, and obviously because there's not the state law on this, it's less clear whether there's been crimes involving machine guns in state court. But in federal court, there's been at least 2 cases in the last 6 years. There's one from 2019, one from 2024, where individuals have been indicted and sentenced for violations of 9220, which is the federal machine gun law. And I'm happy to share those cases with the committee.
Before you go ahead, Zach, go ahead.
Yeah, Billy, what are the cases? Can you give us anecdotally what the cases are?
Sure. There was one from 2024 where it was a person who possessed a unregistered machine gun that lacked a serial number, a privately manufactured AR type pistol. That was the 2024 case. And then there was another case involving an individual who had a older machine gun that had an obliterated serial number on it. And in that case, the 2019 case, the individual was sentenced to 65 months imprisonment. He was also facing state charges, but not state charges related to the machine gun. I believe he had committed other crimes.
Well, that's what I'm wondering. Were these drug related?
I don't believe so. But I can't guarantee that. I can, again, I'm happy to share. These are
it'd be helpful to have that. Yeah, it'd be helpful to have that in terms for witness testimony prior to, citing them in front of a room full of people.
Yeah, no, happy.
It just would be good to have those.
Yep. Yeah, I'm responding to a question that was raised. It was not something I planned on testifying about, but wanted to help the committee on the question that was raised about whether there's been prosecutions. So I'm also happy to kind of get into the weeds a bit on some of the technical elements around auto sears. I do want to be very clear that we at Giffords what we want is we want Vermont prosecutors to have the ability to prosecute machine gun cases in state court. And so, right now there's no state law on this. And so, at a minimum, we would support adopting the federal statutory definition of a machine gun, which would include auto sears, as done through, the ATF system. There is, as Attorney Fitzpatrick referenced, there have been specific rulings from ATF about defining an auto seer. So, I know there were some questions about technical, how's this done? There is an ability to rely on the technical elements of the federal government in order to, do that. We at a minimum would support having, machine guns and then, the devices that turn something into a machine gun regulated under Vermont law. Again, for those reasons I mentioned, that there is presently a capacity gap and there is the chance of a legal gap that could arise. So I do want to get into that. But I know we're short on time, so I think it may be better used if I can just, open myself up to the committee. If there's any questions I can answer about, auto seers, any technical questions at all on that.
Go ahead, Ken.
So just to go back, I'm trying to be clear here. The two cases that you brought up, were there, it wasn't just a machine gun crime, there was more to it than just that? I mean, I need a little more detail on that. What Representative Harvey was asking, what's the details of that?
Yep. So I'm happy to share the federal indictments and the press releases that came out with them. These were done by the U.S. Attorney's Office in Vermont, and happy to share those with the committee. Again, I did not have them before my testimony because I did not know that was going to be one of the things to cover, but happy to share that with the committee.
Yeah, he'll send that in.
Well, that's fine, but I would think if he's brought it up now, he would know now instead of just throwing it out there at us right now. Like it's important for me to know what that is.
Yeah, and you're going to know he's going to share the indictments, which will, rather than him kind of paraphrasing what it is, let's see the whole thing. And we're going to get those, and thank you for providing those.
Are we in kind of a rush for this whole bill to get passed?
Presumably, I'm assuming that he's probably in the motion of getting it ready to send to us right now. During lunch. So questions regarding the technical issues regarding auto seer. Any folks have questions? Yeah, go ahead, Angela.
So I wonder, given your technical knowledge, Billy, if you can, if you have any thoughts on, I don't know, more specific definitions, or I guess to back up, if you have any concerns about the current definitions in section 4 of auto seer and rapid fire device, and if you would, if you have any concerns about potential confusion on the part of prosecutors in trying to bring these charges.
Yeah, absolutely. So to go one by one, no concerns about auto seer because as Attorney Fitzpatrick testified earlier today, that is tied specifically to the federal definition of a machine gun under federal statutory law, as well as the federal regulatory definition of an auto seer as put out by ATF. And that's a regulation that's been around since the 80s and again was cited in that Supreme Court decision as an acceptable use of federal government power to regulate machine guns. So auto seer, no questions on that, no concerns, because again, you're going to have regulatory backing for that. You've got the statutory framework, and you're going to have case law at the federal level interpreting that.
So before you go on to the rapid fire device, so if I understand from Ms. Bradley's testimony that auto seers, if they're registered under this complicated process, are legal federal. Is that my understanding?
There is a small category, yes, of pre-1986 auto seers, and then there's also a very small category of auto seers that can be produced by a certain category of FFL, of federally licensed firearms manufacturers.
And those are captured in the the alcohol firearms, ATF, sorry, the ATF regs. I mean, as far as what those are that are legal if they're registered, is that correct?
That is correct. I'm not positive the statutory language as currently done would include the legality of those legally registered auto seers. Again, that is an incredibly small number. I don't have the numbers in front of me, but it's an incredibly small number from what I'm aware of anecdotally on this. But if you wanted to add in language that, excluded, legally federally registered machine guns from this, that would capture federally registered machine guns, federally registered auto seers as well.
Okay, all right, go ahead. But you were going to talk about, I think, the rapid fire device, I believe.
Yeah, so rapid fire device, I think what I view as the key word there, and again, this was emphasized by Attorney Fitzpatrick, is device. So that a device is not a finger. Um, a device is something that's installed or attached that increases the fire. And so that is trying to capture the universe of objects that are used to mimic automatic fire on a semi-automatic gun, to turn a semi-automatic gun into something that has fully automatic fire. So that's where I believe that the sort of you know the slippery slope is addressed is through that use of the word device. Another thing that I've seen some states do and could be done here is to add examples that specify what you were talking about. There is a list of examples that are different than auto sears. This is something that I know that the expert from Everytown, Greg Lickenbrock, will testify to, I think, later this week. But there's a whole category of different devices that you could specify. And I know that's what some states have done, is just like you all did with bump stocks, you could specify trigger activators, binary triggers, forced reset triggers, different things that if you wanted to do it that way.
Before I get to you, Zach, just one follow-up question on this first. So you mentioned automatic, fully automatic. We don't have that here. I'm wondering if that's where we need to go if we're going to have something like this. Instead of just increasing the weapon's rate of fire or the rate at which the trigger is activated, we should be talking about converting a firearm to a fully automatic firearm. Would you agree that it sounds like that's where we should be after?
I think that's right. My one caveat would be, one approach that I've seen states do is to say that the rate of fire mimics automatic fire, that the rate of fire is to the same level. Again, the devil gets into the details when you say it turns it into fully automatic. Because it depends then in part on how you're defining fully automatic, whether it's a single pull of the trigger or whether it's done through these other mechanisms. One of the things that we've seen the gun industry do a great deal is try to push the federal definition of a machine gun as far as it can and really beyond where it can tolerate in order to get to fully automatic fire in a way that, at least in their argument, does not implicate the federal definition. So to me, the real focus is, are you mimicking automatic fire? Are you getting something that can fire at the same rate of fire as a machine gun?
Yeah, exactly.
Billy, I'm just curious where you're pulling your definition of device from. Is it somewhere in Vermont statute?
I'm not pulling it from that. I'm pulling it from the common usage of the word device. I think it would really strain credulity to try to go in and say a finger is a device. As a matter of statutory interpretation, I think would really be a difficult and argument that would not be able to be accepted by a court.
So, I'm not a lawyer and I'm not going to try the case in front of, prosecute the case in front of the room of witnesses here today, but we've heard from two extremely compelling witnesses that a digit, whether it's a finger or some other device, could be classified as such. And so I guess further opining on that, do you think a rubber band is a device?
So the rubber band and the example that
coat hanger.
Can you hear me?
Yeah, the coat hanger. Is that
the coat hanger example. So there have been federal prosecutions for the coat hanger. That is something that does happen, and that's done in the context of someone who has taken coat hangers, broken them down, and is either selling them to be used as drop-in auto sears or lightning links. There's a lot of different ones. Again, that's where the gentleman from Everytown can speak to it. That there have been prosecutions there in that context. I'd want to think through whether the rubber, the other part that's doing work in this statutory definition is installed in or attached to. I'm not sure the rubber band would work with that. Maybe it works with attached to, but installed in and attached to, that does get the finger part out of it because you're not installing your finger or attaching your finger when you're using the gun. It's not attached in any way.
Right. So we can debate that further, but I guess to put a finer point on it, you're not suggesting, part of your testimony today is not suggesting that we ban coat hangers in the state of Vermont.
I'm not suggesting that we ban coat hangers in the state of Vermont.
Okay, so then how do we enforce this? That's really what I'm trying to get to the point of, is how do we enforce this? If we're not going to ban coat hangers and all the devices that could be used as a rapid fire device, how do we actually make this bill effective?
Yep. So I think we follow the longstanding lead of how the federal government has enforced this in that, the vast majority of any case that's going to involve this is going to involve the Glock switches that we're seeing for sale online in the black market or on through social media. That's going to involve, the lightning links, the drop-in auto sears that we've seen that are showing up at crime scenes across the country that are enabling fully automatic fire to hit innocent passersby. That's where the enforcement would come in, is that there's a longstanding model of this being done at the federal government. This is not something that's brand new.
Right, and that's why I think there is such a long-standing history with the federal government legislating over this that I just don't know why it's necessary for us to do it any further and have potentially damaging carve-outs in the state of Vermont. But my last question for you, Billy, is were you consulted at all on this bill prior to it coming to the committee? Did you have any input on any of the language?
I have been in touch with committee members on
Okay,
this.
so I'll take that as a yes. Thank you, Chair.
Last question.
Yeah, last question. So are you saying don't reinvent the wheel, seeing as we already have a mirror of federal law? We could have a mirror of federal law on this particular issue in the bill, the rapid fire devices and all that. But we could just adopt that and have our own state penalty.
I am saying that adopting federal law in that way would be a huge step forward for Vermont. I do have some concerns about it at the edges, and I do think that the rapid fire device definition does some work that federal law does not. At the same time, I think if this were to go forward with just the federal definition brought in, that would be a huge improvement for public safety in Vermont.
So that way, if we run into one of these devices, we know that it's technically a machine gun and we can prosecute it at a state level with our own penalties.
Yes.
Or hand it off for that matter.
Yes, exactly. Yes, exactly.
Right. So if you have more to say, we can have you back, but it sounds like you covered what we needed to from you. Is that correct?
Yeah, that's correct. Happy to,
Okay.
but I will send those two things that I referenced, the two cases that I referenced momentarily.
All right, great. Thank you very much. And so the witnesses we didn't make it to, including Eric Davis, we will have starting at 1:00 tomorrow afternoon. And I think that includes a few other people who didn't quite make it to. So we're adjourned until 1:00 today when we're taking up H772, an amendment